Why promote IP? I will state now the reasons of why you need to promote IP from different perspectives. What's in it for businesses? What's in it for consumers? What's in it for creative individuals and entrepreneurs? And what's in it for society? For businesses who have a defined IP strategy, first they maintain that competitive edge. They have a product that is not copied. They have a very specific and creative product. They are able to raise funds to develop this product because investors have confidence that the ideas won't be stolen. And they are able to protect their innovative ideas, which use new technologies and designs or unique selling points from exploitation by unscrupulous traders, from plagiarism, from copying them, etc. This is from the business perspective. From the consumer's perspective, a consumer, he will have confidence that a product with a trademark is a brand name and it has been manufactured up to a certain standard and quality. He will have also in the market innovative products to choose from. This is from the consumer's perspective. From the creative individual and entrepreneur's perspective, they will have time to develop their innovative ideas because they know that it's protected, let's say, for the life of a person plus 50 years. They will keep on developing it. They have the time to improve it, to make it a better product. They will reap financial rewards from their ideas, especially when they license it or franchise it, or for example they do strategic alliance, or they find an industrial application for it. They will sell it in the market and get paid for it. Plus there is this personal fulfillment perspective. From the society and the economy perspective, there will be growth in enterprises and growth in creativity. There will be innovation. There will be vibrancy. There will be increased and varied employment opportunities. New jobs are created. There will be a reputation for innovation. So these are the reasons from different perspectives why we need to promote and protect IP. Plagiarism. Plagiarism is stealing or passing off the ideas or words of another one as one's own. Like if I come to you and I quote, and I say a quote, and I say I said it, while let's say it's Plato who said it, or it's Obama who said it, or somebody else. It's a use without crediting the source. So basically, it's either claiming that I said it while it was not me who said it, while it's saying it, or it's saying it without crediting the source. Common example of plagiarism, like reproducing someone else's work without quotation marks or proper attribution, like in our earlier case study, like paraphrasing or summarizing another's work without attribution or acknowledgement of the source and submitting it as your own, like a deliberate attribution to a source from which the reference material was not in fact derived, so a wrong source. And finally, like failing to cite a source for ideas or information. How should SMEs protect their IPAs, their creation? How should they get intellectual property rights on a specific creation? There are 7 steps. I will go through them, explain them, and then we will have a case study on the basmati rice, and we will be done. So bear with me for 5 more minutes. So in order to protect your IPs, first you have to do an IP audit. You have to do an IP inventory inside your company by capturing and analyzing your information and knowing in your products and services what can be protected as IP. You make an audit on all your products and services and you write down. If you are conducting an IP audit for the first time, you may be surprised at how many IP assets your company has and how valuable they are for your business. Plus, intellectual property audit, it may uncover potential risks to your business that could ultimately result in costly legal proceedings with employees or third parties. So, two steps to do your IP audit. First, you identify your IP. Second, once you identified your in your products what can be protected by intellectual property, you have to assess what is your right in relation to each of the IP items identified. Can I protect it under copyright, under trademark, under patent, etc.? This is the first step. The second step is to register it. It's very important because if you did an IP audit and didn't register it, it is still inside your company. Any of the employees, contractor, advisors to your company, and register it in his name. So you have to register it. You have to keep a record. You have to keep minutes of all discussions about a product that has IP. You have to keep all your research, your drawings, your designs, your discussions, anything related to your brand, to your invention, or to your product. You have to keep a record of it. The fourth step is a non-disclosure agreement. An NDA or a confidentiality agreement, it allows a company to share its IP with others whose input it needs without unduly jeopardizing this information. For example, like if you have a new product or feature under development and you needed to consult an expert for advice on how to proceed, how to develop it further, you can sign with him an NDA and ensure that this expert he will not hand the details of your product to a competitor of yours. This is an example of protecting via non-disclosure agreement. Same thing for IP generated by contractors and clients and IP generated by employees. The thing is, whenever you're working in your company, you have your employees, you have contractors, and you have clients. If you have a product that has IP, in each contract that you sign with an employee, a contractor, or a client, or an advisor, or an expert, you have to define property of IP, it goes to whom. Because if you don't define it, like any employee, contractor, and client can steal it and go register it in his name. This is why it is recommended inside your contract to put a clause related to intellectual property and the ownership of it to you, or like let's have between you and the employees. Like it depends on your policy. If you keep the property of IP to yourself, you will demotivate employees. If you give a certain percentage of this property to your employees inside the contract, you will motivate your employees to perform better. It depends on your policy, on your strategy, but it is important inside the contract that you sign with an employee, contractor, and client to define to whom the rights of intellectual property goes, because this later on will entail financial rewards. The seventh step is due diligence. So before, like whenever you're going to register, before you register, you should conduct a clearance search inside the national offices to see if your trademark, your patent, your design has been already registered, or it does not conflict with any prior registered IP rights. Because if it's registered, if it's already registered and you have put all this money and all these human resources in developing a product that has creation inside it, and you discover later on that it's already registered by someone else, it's very embarrassing either to rebrand or to redesign the product after launching, or even you can be sued by an IP owner, by the other IP owner. So basically this is very important to do.